May it please the Court, we are here today asking the Court to set aside the June 2006 order due to the constitutional violations committed upon the father and his minor child, namely violations of procedural due process, substantive due process, equal protection, and associational rights. I've been practicing law for 26 years, and I've never considered my client's constitutional rights until this case. And I believe that's because a parent's constitutional rights in the divorce arena is simply not taught in law school. It's not practiced in the courts. There's very little case law on the subject.
Ms. Road, can I get you to pull the microphone a little closer to you?
Yes, I apologize. Is that better?
No problem. That's good. Thank you.
So it's very common that the current procedures for determining custody of children in divorce completely ignore the parent's constitutional rights. And we see it so much that we really fail to see it. But I'm asking you to set aside your preconceived notions of divorce practices and look at this issue squarely from a constitutional framework. And if you do, the logic will lead you to the conclusion that the 2006 order was unconstitutional. Before I answer the Court's questions posed to counsel, I'd like to just give a framework of what has helped me answer these questions, and it's a flow chart. And I'll be referring to it in answering my questions to you. And we start with the 2006 order at the top of the flow chart. And from that, we ask the first question is, did that order violate my client's procedural due process rights? If it did, our inquiry stops there. You don't have to ask any of the other questions. It's void. It's due to be set aside. If your answer to that question is no, then the next question in the flow chart is, well, did that order infringe upon a parent's fundamental liberty interest? And I don't think there's any dispute that the order in this case did infringe upon my client's fundamental liberty interest guaranteed to him in the Constitution. So the next question is, if it did infringe upon that fundamental liberty interest, did it do so with a compelling interest? ERG tells us no, there was no compelling interest. But even if this Court were to find that there was a compelling state interest to infringe upon his fundamental liberty interest rights, the next question is, did the state do it infringe upon his fundamental liberty interest rights in such a narrow way? Was the order tailored so narrowly and give the least restrictions on his fundamental liberty interest to meet the compelling state interest? With that framework, I'm able to answer your questions, and again, I believe it will lead us all to the conclusion that the court order is unconstitutional.